unfortunately, the operation of the Airports Authority is now becoming a poster child for some of the corrupt practices that I think need to be brought to a halt and accounted for. Nepotism, both some from some of the key personnel, including I guess the personnel HR director has resigned, but also even board members. But it was an anonymous employee survey, and they gathered comments in 2010 of some of the extensive mismanagement issues at the authority. But some of the comments that are in the report, which again hasn't been released, I don't believe are finalized, this is what some of the employees: stop the corruption, favoritism, discrimination, hiring advancement of unqualified people, top management people, VPs having board members in their pocket for favors, VPs violating laws, practices, and lacking ethics and fairness.
Excessive salaries, questionable cash awards, and ineligible benefits. In one case, MWAA created a new position for a former board member that included an annual salary of $180,000 for unspecified job duties before terminating that position.
Publication about a contract that was given to a former board member where this board member was going to be paid for an extended period of time as a consultant. And when I read the article, I couldn't believe it.
The accusations were against the board members, some were against personnel. Where are they now? And Mr. Curto, you said there's only 2 left of the old members, is that?
That's correct, Chair. As of the new year, there'll be only 2 board members that have served more than 2 years.
You don't want the same cast of characters or violators in positions of trust. And we're going to clean house on the board and with employees and restore the confidence.
Contracts with spouses, law firms, are those things still in place?
That I don't know.
Mr. Curto?
No, I believe the contracts, all contracts with former board members, former employees have been terminated. With respect to relatives of employees or board members, let Mr. Potter address that specific question.
We are looking at all hiring that has been done in the past 5 years to determine how people got on board.
So it's your wife works at the law firm that has the contract with the authority?
No, the circumstances relating to that were as follows. The authority requested an opinion of counsel from a law firm. I was not chairman at the time. I was not on the legal committee at the time, and the general counsel for the authority made the decision to retain the law firm. My wife at the time was an employee of that law firm. She wasn't an attorney. She wasn't a partner in the law firm. She had no direct or indirect financial interest in the law firm.
Can I just ask, was that also competed, or was that just a sole source contract?
It was a decision by the general counsel, and it was a sole source contract.
Mr. Scoville, is there a problem with that?
Although it wasn't an actual conflict of interest, it certainly was an appearance of a conflict of interest. And at the time when the interim report was issued in May, I immediately made a statement recognizing, stepping back, that prospectively any actions I take would be to avoid even the slightest appearance of a conflict of interest.
If I may, these are the facts as determined by my audit team. And on November 18th, 2011, members of the board instructed the general counsel to obtain a legal opinion on that legislation. When the general counsel asked members of the board for possible candidate firms, a board member, Mr. Curto, not yet chairman, but still a member of the board, suggested a firm where his spouse serves as the director of administration. The general counsel then contacted that firm and arranged for that firm to begin drafting an opinion on the legislation. It was a sole source contract, and it was executed without the immediate knowledge or involvement of the procurement and contract department of the authority.
It does strike me that whether for appearances purposes or for actual conflicts of interest, it sure would make sense to find another lawyer, and if you need some help, I'm sure there are plenty of people who can do that. Let me just, how many children and grandchildren of board members are still employed by the authority?
Well, we do not have an exact count. We're going
Is it
through a process.
more than one?
I would, yes, it's more
More
than
than
one.
two?
I don't have an exact count. We are going through a process right now of having all of our employees fill out a form that identifies relatives either within the authority or on the board. And that process is currently underway, and once that process is complete, we'll be able to know.
Mr. Scoville, in your view, does it present a problem to have close relatives who are relatives of board members as employees of the authority?
Clearly it does. And I would like to point out, Ms. Edwards, that for a long time, the code of ethics that applied to employees, to the staff of the authority, prohibited nepotism. Yet the code of ethics, until recently revised, that applied to the board of directors was silent on nepotism.
With respect to the contract with the board member that is now apparently terminated, I take it, how did that come about? Who asked whom to authorize the contract, and who approved it?
Both Mr. Curto and Mr. Potter engaged in, shall I say, missteps or misjudgments in their service on the authority. Mr. Potter determined that he needed a new position with a certain person in mind, and that would be the former board member, but he did not follow standard processes to create or fill that position. This was an advisory position for a board member to occupy immediately upon departure from the board. It did not have a specific job description, but it did have a paycheck, $180,000 per year, beginning one day after that board member left the board. There may indeed have been a legitimate and compelling business need to secure the services of that former board member, but the process to create and fill the position was unsatisfactory. And this is the case that's highlighted in our issued report as an instance where senior officials circumvented established hiring positions, both for current positions and also for new positions, to the detriment most certainly of the credibility and integrity of the authority, and perhaps to very harsh effect on the morale of all the rest of the staff who knew that this was going on.
Mr. Curto, was that contract to the board member let under your leadership?
Yes, Mr. Potter did employ that former board member this past year while I was chair.
And was there a conversation or other that ensued with other board members with respect to this, or was that just a decision between you and Mr. Potter?
It was a decision made by Mr. Potter, and he conferred with me.
Did anyone else on your board ask you to engage in this contract with this former board member?
No.
Did the former board member ask you to engage her in a contract?
No.
And so you and Mr. Potter made the decision, independent of anything or anyone else, to let a contract with the former board member?
It was principally Mr. Potter's decision, yes.
So you didn't sign off on it or anything? But it was under your leadership that it happened?
Yes, it was during my tenure as chair, yes.
But on the board members who were in place over this period of this kind of behavior that is, a lot of which is unethical, who knows what other labels we would attach to it, how many of those board members remain?
Everyone else will have had a tenure of less than 2 years, some as few as obviously weeks as of January.
Just as a matter for your consideration, do you think it's appropriate to remain on the board and Mr. Potter to remain as CEO while under your tenure these actions took place?
I would hope so. I think the body of the report, most of the findings and conclusions of the Inspector General's report occurred prior to my time on the board and certainly prior to my tenure as chair. Certainly an appearance of a conflict. It wasn't.
Well, the retention of the law firm at, I think, $100,000 and the contract with the former board member of $180,000, the travel and other missteps of who knows how many thousands of dollars. It's not just a simple matter, and with that I yield. Thank you, Madam Chairwoman.
Regarding the employment of your wife's, the law firm that your wife worked in an administrative capacity, didn't have clients, wasn't going to lead to a better paycheck for her, did you tell the board that she was employed there when that contract was let?
In my financial disclosure, I made it clear that my wife worked at that law firm. That's part of the normal financial disclosures. And when discussing it with the general counsel, I did.
You did?
Yes.
And the general counsel didn't have a problem with it?
Well, I don't think I'm not sure it was brought to his attention at the very outset, but I think once I helped facilitate, the outreach, I then did tell them.
When on the boards that I've served on in the past, we always brought that out to the open. That kind of a discussion was not made?
It was, that discussion took place after they had been retained.
After they'd been retained?
Madam Chairman, just to add to that, and I think it may have just been clarified, but my audit team was informed by the general counsel that he was not aware at the time that he contacted the law firm and arranged for them to provide the requested legal opinion that Mr. Curto's spouse worked for that firm.
Okay. The other troubling aspect that I have is a former board member that is brought back at a substantial salary, $180,000. That's actually more than what a member of Congress makes, so it's a pretty substantial salary. Was brought back without any vetting, and a special position was created for this individual. Am I correct? That position wasn't there before? Mr. Potter?
That's correct. Now, in hindsight, as I've told the press and have readily admitted, my judgment was not good in terms of the hiring of that person.
We were looking strictly at the process by which he was hired and the apparent circumvention of established hiring processes for creating the position and then filling it. When my audit team went in and looked at a sample of contracts that had been awarded using these categorical exceptions, we found 56% lacked adequate justification. So we couldn't tell exactly what was the basis for executing particular contracts under these so-called exceptions.
If I was a member of a board and my CEO took action and chairman took action without me really being involved in the yay or nay, I as a board member would be pretty upset about that action, I have to admit. To be honest with you guys, this sounds like a can of worms. I mean, sitting here listening to this.
The prioritization of personal agendas excluded consideration of the best interests of the authority. And that's replete, our report is replete with examples of it. I am sorry to say the fact that since 2003, 7 former board members and affiliated firms have been awarded 30 contracts amounting to almost $2 million. Out of those 30 contracts, 26 were for lobbying services. That raises at least the appearance that these contracts were nothing but a parachute for departing board members. One former board member was awarded 16 sole source contracts, totaling $262,000 over the past 10 years. The first such contract only 3 months after the member left the board. Another former board member was awarded 8 contracts totaling over $500,000.
Mr. Potter, you said you didn't understand about the category issues. How could, as a CEO, how could you not? You said you only found out about a couple months ago. How could you not be aware of these?
No, I was not aware of the use of categorical exceptions.
In the military, we have a thing called lack of confidence. And to be honest with you, gentlemen, I have a supreme lack of confidence in your board. And if it was up to me, which it's not, I would dissolve the board and create a new one.